mechacha Emma Obi Biara Akwaba Daily Trends and one or so egusu said ya da ya de every mono and then so and some IDT and woman Ghana and Yama would draw a castle and a de bremo young semeno young call and semino emo
be guilty on counts 1 and 4 while Akonta Mining Limited was convicted on counts 3 and 6 after ruling that the prosecution had proven all the essential elements of the offenses beyond reasonable doubt. The convictions followed the court's dismissal of a last-minute application by the defense seeking to delay judgment and refer constitutional questions to the Supreme Court. The application filed on July 16, 2026 argued that constitutional issues raised in the defense written address required interpretation by the Apex Court. However, Justice Kokobite held that Section 99 Clause 2 Subsection B of the Minerals and Mining Act 2006 Act 703 was clear and unambiguous and did not conflict with Article 19 Clause 11 of the 1992 Constitution. Now, citing that particular decision, the judge said constitutional referrals were only necessary where genuine ambiguity existed. And this issue was raised in council. Said Parliament ought to have legislated differently. That is not a matter of constitutional interpretation. And a court no hold here. The assignment of mineral rights on counts 1 and 3 relating to the unlawful assignment of mineral rights without approval from the minister responsible for lands and natural resources. The court held that the prosecution had established all the required elements of the offense. After so, Justice Kokobite said the prosecution was required to prove that Akonta Mining had the mineral rights, that those rights were transferred, assigned or otherwise dealt with, and that the transaction occurred without ministerial approval. We a council and a judge no eboboso na eno na in PTV yede brew because court now find the Chairman Wontumi serious charges are. These charges has raised serious alarm. Na Chairman Wontumi the court found that the absence of ministerial approval a ministry for lands and natural resources and jam to such Chairman Wontumi enko to gold and now say onko to minerals bia awo omasase so eno ye one count no. Now, court now start finding the absence of ministerial approval was as undisputed. There's a obedient means see one quite say a yampa say Chairman Wontumi anje approval bia ampa Chairman Wontumi so lawyers and to provide anything in relation to that ebema who say ampa or GBB free. Now, evidence from the Minerals Commission outlined the approval process, while the accused persons admitted that no such approval had been obtained. The court also rejected the defense claim that Henry Okum was only permitted to reclaim delegated portions of the concession and was not involved in mining. And the court also rejected such defense by Henry Okuma. No, as it was permitted such actions or more reclaim. Baby almost say assassin almost say assassin will be back to its natural state. Now also court rejected. Justice Kokobite said the circumstances surrounding the arrangement showed that mining activities were taking place. The judge relied on Okum's testimony that he was a small-scale miner and had not received funds to undertake reclamation. Instead, he said he was allowed to mine unworked portions of the concession and use proceeds from the activity to finance reclamation. The court noted this evidence was not challenged during the cross-examination. The court who said Okumi nisika na wo expect say obetim dia reclaim assassin any no more nyina court ne say omu ne say wantimi anya saade no afezu no wanya any license and authorization by anybody say onfanye sa no ma no. The court say during cross examination omototo na no want not provide any evidence ekire afezu no. Justice Kokobite described Wontumi's explanation that Okum would recover his investment through future coconut farming as an afterthought. Court no chere say Chairman Wontumi ncheche mu o chere say eye okum ebe recover eye bibia ewo eye ade ni mu say omedua eye koko coconut ewo asase no so no eye nadwen a odwen after say sa de ni siye kobe na nko be dua ni nyina no oboa ohuru say ade na ni nyan no e na obekasa asam na kire court. This is asemwa Justice Kokobite edeba. Now the court therefore held that allowing another person to exercise Akonta mining's exclusive mining rights amounted to an unlawful dealing in mining rights. Now corporate veil lifted. I don't know. Although acknowledging that a company is a separate legal entity from its shareholders, the court held that the circumstances of the case justify lifting Akonta mining's corporate veil. Now Justice Kokobite found that the company did not operate through functional board of directors and that Wontumi exercise effective control over its mining activities. Let us say Chairman Wontumi the ono ane pe ene ye nya wo pe awoni any board of directors obi no odi eye ni company nanim say mpanifo bi ete so a mo betimi atoto adwene ama eye company no enti de ebobo ba no na in last no kra no facilitating unlawful mining no on 4 and 6 counts 4 and 6 court no finding Wontumi and Akonta mining guilty of purposely facilitating unlawful mining activities. And the accused Henry Okum to access the concession and undertake mining operations without the approvals required under the Minerals and Mineral Mining Act. The court also found evidence of deliberate facilitation, citing testimony that Wontumi introduced Okum to a person who assisted him in acquiring an excavator for the operations. Although the defense argued that the arrangement was solely for reclamation, the court held that the evidence established that permission extended to mining activities. It's the way someone court no any charges or they bought Chairman Wontumi gidi and then papa and he said Chairman Wontumi penny difference or provide court no rejecting say in the mining act no Chairman Wontumi before thereby a reclamation and some more kind or say afterthought after so no Chairman Wontumi need the license after Chairman Wontumi approval be free Lands and Minerals Commission natural resources for no Nina Watombra until he should go to jail for 20 good years. Where a someone elbow baba is simply a diabetum. Now, the be a free chamber be asono, ya de bremo, and he said, per the actor, Chairman Wontumi, Gifono. Justice Kokobite, release there is dissatisfaction with Parliament's choice of legislation, which could not form the basis for the constitutional interpretation. And you know, ani ayenyan e dia ma Chairman Wontumi asemwe ya papa na court na convict Chairman Wontumi Akonta mining and after so Mr. Entria omunyina pe ndiye ko chese Chairman Wontumi ko dem 20 good years na hodo don kakra as a lawyer no also defending the client at all costs na otimi eboa no na ono obe defending no na hodo don kakra tinko be hia emre na anka judgment yi ankomode be o ma twentwen so na anka aboa na wotimi aka nsemu a ewo se okamboa na application a o file for Chairman Wontumi no abawi in fact court na bo asem na to agu a boba senka o chese Anaka High Court Senator has dismissed an application by lawyers for Bernard and Chibo Siako, popularly known as Chairman Wontumi, seeking an urgent hearing of a request to adjourn a motion for the deferment of judgment and a constitutional referral in the case involving him and the Akonta Mining Company Limited. Now, presiding judge Justice Audrey Kokobite said Chairman Wontumi and the council should have informed the court ahead of the proceedings if he was unable to attend. Now again, if this requester attach here request here no an answer application file here no ICP no and then ebuboba the ebuboba ne say judge si abasemia to meaning say attach here amwa chema Wontumi chema Wontumi asemia kodu level 6 count ni nyina ye dia bono na the ebuboba eni nyama chema Wontumi because open court and a judgment baswa attachia a travel outside Ghana na enam say Wontumi any lawyers only lawyer be a wodi nanim ono lead counsel no judge no abasem na to ogwa wo se ko bona mane obo court na mane ansa no decide ayenia opese oye na if say what decide ya omoje court no muni mu asem biaka na ne abuboba ne say right now no chema Wontumi before proceedings no plead not guilty say ono odi for o asem nim na odi bem pe enoma omoni toto ho ede ma chema Wontumi by ni first counsel onu di animu de ma no chese chema Wontumi ni for but in some p near ebuboba chese chema Wontumi ahwe yakwako for 25 years per ne counter is 6 count no one